through these, okay? And then once you finish reviewing them, let me know, please.
Are you looking for copies or what do you?
Yes, Your Honor.
Okay.
May I approach?
Yeah.
Is this the,
One page isn't redacted though, so I got 1 and 2 that are
Okay,
redacted.
I'm gonna. Can I use it as a reference? But I won't.
Yeah,
The
as
one
long as,
that's submitted.
as long as it doesn't get published. Sure.
okay, so I read this, okay.
Sir, let me ask you some questions, okay? Now, the first page is the daily prayer that Ms. Barnes posted on her her public Facebook post, correct?
Mhm.
Is that a yes, sir?
Yes.
Yes, thank you.
Okay.
Yes,
And the second page is what you wrote in response to her daily prayer that she had posted on her Facebook page, correct?
yes, but there's,
Just, the prosecutor will be able to ask you any follow-up questions, okay? I just want to focus on what I want to ask you about, okay? Now, with respect to your post, you basically suggested that she was a devil in sheep's clothing because she cursed.
let me correct you
Correct?
there. No, I did not.
Is
Let me
that what
correct you
the-
there. It was a sheep in wolf's clothing, not a devil. It doesn't ever mention anything about a devil.
Sir, okay. Do you have page
On this
2
here?
in front of you?
I don't see it here.
Hold on for a second.
Yeah.
I can't read upside
Go all the
down.
way through it. It doesn't say anything about a devil. It's a sheep in wolf's
Hold
clothing.
on for a second. What is that? What is that word right there?
Beware of the devil, sheep's, okay, so it's in sheep's clothing.
You said you called her a devil.
Either way,
in
yeah.
sheep's clothing, and you
Yeah.
referred to her as having demons. Correct?
Yes,
Okay. And this is not the only insulting that you did towards her during the campaign, correct?
Objection relevance, Your Honor.
It's,
When, under what circumstances?
and may I just move for admission of this defense
Sure.
exhibit number 1 that contains 3
Page
pages?
1, 2, 3.
Do you want me to hold on to it or give it to you, Judge?
Did you already mark it yet? Any objections to defense 1, 3-page document?
No, Your Honor.
And I'm sorry.
Heather will mark it.
Okay. Moving on, Your Honor.
Thank you.
You then decided you were going to file a police report against Ms. Barnes, correct?
correct, I did.
Okay. And you went to the police and you met with a police officer. Was it 1 or 2?
There was 2
Okay.
detectives,
Okay.
not police officers.
And you initially told the police you had never called her name, correct?
Pardon me?
You told the police you never called her name.
Your Honor, objection again is irrelevant.
It goes to.
Your Honor, we've been over the defense counsel's desire to indicate that there was a motivation or that Mr. Bowman was asking to be threatened by Ms. Barnes. It's not relevant.
And
It's,
our position is, Your Honor,
I know what your position is, but I thought I made mine pretty clear. That
so I can't ask him about comments he made with the police?
I told you I would let you get into that.
I'm talking about his police interactions now, only.
Go ahead.
with the messages, you told the police that you really weren't concerned about the messages other than the one that where, that said that if she, now you told the police that you weren't concerned about any of the messages other than the one that referred to your wife, correct?
I mentioned that, no, I don't, not that I wasn't concerned about it. That's what caught me. That's what, that went too far. I was concerned about the whole situation. But when you start mentioning, you're gonna break something like that off and you're gonna find it coming out my wife has nothing to do with my political campaign or anything else.
Sir,
She's
you didn't
threatening my
understand
wife.
that was, the message was, you're in for a rude awakening.
My
You're
message
going
was,
to- No, I'm reading the message so I can ask you a question about it. This is the message. You're in for a rude awakening. You're going to end up going back to selling Christmas trees. That's what's going to happen to you. You're barking up the wrong tree with this black bitch. Sheena then barks several times, "Woo, woo, 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 woo," and then says, "Bring it on, trust me. I'm going to be sitting right next to your ass until we get done with you. Recall your ass, all of y'all, and make sure you let them hear this shit. I'm going to stick my stick up your ass, and when I get done, Tim, you can find it coming out of your wife." Now, that's the reference you're talking to relative to your wife, correct?
yeah,
Okay. And you don't believe that that's coarse joking, sir?
I don't believe what?
You don't understand that that's a forced joke? That she
A
can't
coarse
stick a stick
joke?
up your ass and it come out your
I should
wife?
consider that as a joke when somebody talks about sticking a stick up my ass and it comes out my wife. You consider that to be a joke, a coarse joke, whatever you want to call it?
While
I
you were
don't consider
talking to-
that a joke. I consider that a threat.
Okay,
I
while
have
you were
never been-
talking to the police, you also called somebody a dumbass. Weren't you joking then? It's relevant to, he's accusing her of something he does.
Your Honor, again, it gets to the fact that we're essentially insinuating the victim was asking to be threatened by the defendant.
No, we're not.
It's
We're-
not relevant if he makes comments about other people. What is relevant, Your Honor, is if Ms. Barnes threatened Mr. Bowman on August 19th. That is the issue for the jury.
Here's my problem. How is it relevant if he might use coarse language and jokes as to whether or not what was said on August 19th was a joke?
So that the jury can evaluate the alleged crime that she is accused of, if he's doing the same thing.
How is that relevant? The fact that, once again, I'll go back to the
Okay,
assault
you
and
know what,
battery
Your Honor?
analogy.
I don't think that,
Let me finish what I'm saying. I'll go back to the assault and battery analogy. If,
I would prefer that we excuse the jury, Your Honor. Again, if you.
take a break, folks. Mr. Bowman, you can take a
So
break
sorry,
too.
ladies and gentlemen.
What you're asking me to do is say it's okay, it's relevant for you to talk about coarse language that he used with the officers to explain that the coarse language she used on the phone message on August 19th was a joke. How could it possibly have anything to do, conversation between Mr. Bowman and somebody else, not Ms. Barnes, how could that possibly be relevant for them to decide whether or not what they hear on that tape was a threat or a joke?
His understanding and his use of coarse jokes is relevant relative to whether or not he truly believed this was a threat. That's all I'm trying to do to defend my
How?
client.
I'm asking you,
How?
I know
Because
what you're
he
trying to
does
do.
the same thing she does. So if he's making coarse jokes, he should understand what a coarse joke is.
So
Particularly,
then ask him, have you ever told a dirty joke? Have you ever told a coarse joke? The fact that he used coarse language in a situation when he was talking to the officers,
that's relevant in my opinion, but if you're prohibiting me from asking
if
him
you want to
questions-
ask him about his use of coarse language, I think that's relevant. No, and I don't even know, I think that's a stretch, because the statute doesn't say he's got to be offended. It says he's got to feel intimidated or threatened. So if you want to focus on the intimidation threat end of it, then quiz him about why he felt threatened, why he felt intimidated. I doubt very much if it was the use of the word ass.
And Your Honor, I think he's already answered that question. He's made it clear that it was because it related to his wife, who in his mind was not part of this. Whatever political dispute Ms. Barnes may have thought she had with Mr. Bowman, his wife does not hold any political office in Sumter Township, at least as far as I'm aware. And I don't know how that's his answer to that question. I don't know. And I think I'll let her answer the question before I object, but I think, questions on prior use of telling of jokes, it's not relevant to this either, because it still doesn't negate
It's
what
threat
she
or
did.
intimidation. It's threat or intimidation. I mean, if you had some evidence that Ms. Barnes and Mr. Bowman in sometime in the past bantered back and forth with that exact same language and he never made a report and now all of a sudden he does, I guess that would be relevant. But he's made it pretty clear that the language about the stick in his ass coming out of it and finding it in his wife, that's what he found to be objectionable. Now, you can quiz him about what was objectionable about it, because if he was just offended, I don't think that violates the statute. I don't see that anything in the statute that says that she can't offend him on the phone.
Very well, Your Honor.
Your Honor, may I have 30 seconds to run the
Sure.
bathroom? Thank you, Your Honor.
Keith Haynes is being promoted.
Okay.
And I like it. I just know he sent me a text and said he's scoring surgery. If I can attend. I think that's a good. That's what happened. It's pretty well. It's very good. It was, I think it's the middle of the day. I think it's like noon or 2 or something. Yeah, it's not, I know it's not in the morning because I looked and I thought, I can try to do that. But I don't remember now. I know it wasn't. Yeah, that's what we were talking about. I think it's a good promotion. July. So, just from control to start. Oh, yeah, just cute as can be. Thank you, folks. Yeah. Mr. Bowman, come on up front. Still under oath, still warned you about the incline ramp. So folks, before we get back on questioning, you talked about lunch. I understand that you're thinking about 12:30 and you want it short as we can make it. All right. So number one, I'll stop it at 12:30, as close as I can to 12:30. I don't want to stop in the middle of a witness. You know, I'd like to be able to get finished up with a witness, even if it's a little earlier or a little bit later. We'll break for lunch. I'll tell everybody 1/2 hour. It probably ain't gonna happen. There's a thing called court time. Sometimes things just get away from us. But let's put it this way. As soon as you're back, the rest of them are in trouble if they're not ready to work. Okay. So we'll call it a 1/2 hour and I'll do the best I can to keep it to a 1/2 hour, keeping conscious of how valuable your time is. All right. Ms. Young, your witness.
Thank you, Your Honor. So what you found objectionable, Mr. Bowman, was what Ms. Barnes said about the stick up your ass and then finding it coming out your wife, correct? That's what you found objectionable, correct?
I find the whole thing objectionable.
Okay. Well, while you were talking to the officer, you also laughed and said, she's fucking crazy. You're laughing about it. You agree?
I would probably I probably did say she's crazy.
And you were laughing about it.
I was trying to find some humor in it.
I see. And you're still communicating with Ms. Barnes, although you think she allegedly threatened you,
I
correct?
don't communicate with Ms.
You didn't send her a thumbs up on May 18th?
You're not object to the relevance of anything.
It's relevant, Your Honor, as to his claims.
What happened there?
I'll allow it. Go ahead.
Didn't you send her a thumbs up to her
What
phone
happened there?
on May 18th?
Okay, so what happened there? I was going through the messages to make sure that I had all the messages. I accidentally hit it. It was instantaneously. I accidentally hit send and it sent her a thumbs up. That's what happened there.
I see. Okay. And then you called her yesterday, didn't you?
What now?
You called her yesterday, didn't you?
That's when no, I did not. Unless when I hit the send, it called her. I hung up immediately. Yeah,
I see.
okay,
Okay, nothing further.
yeah.
Redirect.
I have no further questions, Your Honor.
You can sit down, sir. Watch your step.
Our next witness is Detective Sally.
Thanks, Ken. You're welcome, sir. morning, Detective. Come on up. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth. Have a seat right there. Settle in, spell your name, state your last name. Not a witness?
No, Your Honor.
Go ahead.
George Salajan, last name's Salajan.
And Detective Salajan, are you employed?
Yes,
Where?
Sumter Township Police Department.
How long have you worked there?
Coming up on 10 years.
And you are currently a detective?
Yes.
How long have you been a detective?
3 years, 4 years now?
In late August of 2022, were you involved in the investigation of a complaint by a Tim Bowman?
Yes.
What was your involvement in that investigation?
We went around and took statements from people that were involved.
Did that include speaking with Ashina Barnes?
Yes.
So you personally spoke with her, or was involved in conversation with her about your investigation?
Yes.
And what did that consist of?
Well, there was a lot of talk about the, totality of everything, and mainly focused on these voice messages that were received.
During the course of your investigation, did you have occasion to ask Ms. Barnes if she had made a voice message to Mr. Bowman?
Yes.
And did Ms. Barnes admit to making the voice message call on August 19th to Mr. Bowman?
Yes.
I have nothing further for this witness.
Your witness, counsel?
Morning, officer. Detective, sorry.
Good morning.
You would agree that based on your interaction with Ms. Barnes, she's quite a jokester, correct?
Sure.
Was it your body worn camera or your partner's that she threw the kiss at?
I want to say it was mine.
Okay, and she was also referring to her her roadside food stand as a sardine can, correct?
I believe that she called it that. yes.
Okay, that she pays her taxes and pays she uses it to pay her taxes so you can get your check, was her comments, different comments like
I'm
that.
gonna object to the relevance of these questions about
Judge,
whether or not she was joking in an interaction with police officers. I don't know how it's relevant to whether or not she threatened Mr. Bowman on August 19th. I don't know that we're alleging that she doesn't have the capacity to make a joke. What we're alleging is that during the call on August 19th of 2022, it played for the court that was a threat. And so I don't know how these.
And I'm gonna object to the prosecutor describing it as a threat. That is up to the jury.
Well, yeah, but that's her theory. That's the way she sees it. I'm gonna explain to the jury, it's for them to decide.
Judges, this goes to his interaction, since she called him as a witness, and the type of interaction he had with Ms. Barnes regarding this incident and how she's a jokester.
And
That's
it's
all.
character witness or character evidence. It doesn't, whether or not Ms. Barnes has the ability to make a joke does not get to the issue of whether or not.
I agree.
that call was a
I
threat.
agree. I think what would be more proper, counsel, is if you asked him based on his interaction with her, how he saw or what he thought of the tape here. Because August 19th, that telephone call is the crux of what they have to decide as a jury.
Thank you, Your Honor.
Right. They also have to decide whether or not
Counsel, I've made my
her
ruling.
intent,
I've
her
made my
intent
ruling.
is at issue in this case.
I've
Your
made
Honor.
my ruling, move on.
Okay, but the court does agree that her intent is at issue, what her intent was.
Absolutely.
Okay. So I'm asking these questions to
Ask
show
your question. The
relative to
argument
the
is
intent.
done.
Okay,
I've made my ruling.
okay, thank you, Your Honor. Just 1 second. And it's your opinion that that didn't think that Sheena was going to do any type of violence? She's never been known to be a violent person, correct?
Objection, it gets to her character again, Your Honor.
It goes to intent. It does go to character. Her character is on trial. It's and her intent.
It's not.
Could Ms. Manorino finish her objection?
Sorry.
Your Honor,
Bless you.
Bless you.
it's not her character, it's what she did on that, the August 19th date. That is the issue for the jury to determine. And the character of whether or not she's a violent person or whatever counsel's trying to allege is not relevant to whether or not on August 19th, she made a call that threatened Mr. Bowman and his wife. That is the issue for the jury to decide. And these questions about whether or not she has some propensity for violence
Is relevant.
are questions about her character that are not relevant to this issue, Your Honor.
Response.
It is relevant, Your Honor. She's been accused of making an alleged phone threat. When her position is she was joking, it was of course joking. This officer has dealt with her, interacted with her, and he has commented on part of the interaction. And if the court doesn't want me to ask him any further questions about her, then I will not. What relative to her.
Well, if I sustain the objection, that doesn't mean I don't want you to ask me any more questions about her.
With
I don't
respect
want you
to
to ask
violence,
that question about her.
is the court objecting to my question about
I'll allow it.
officers thinking about whether she
I'll
was a
allow it.
violent person? You did not think that she was a violent person, did you, officer?
I have no personal knowledge of Spartans being violent.
Is it in the police report that there was a thinking that she was not a violent person?
I'm not certain if that was real. If it was in the report by another officer, then that would be their knowledge.
Would that have been a jointly written report by you and the other officer?
There would be several different parts of the report that were.
If I show you the report, would that help you refresh your recollection?
What was that?
If I showed you that part of the report, would that help you refresh your recollection?
Sure, it's in the report.
And this is from the second report.
I'm not sure who wrote this. May I approach?
Yeah, yeah.
Either way, I don't recall. Correct. Detective Lieutenant Toth stated that he didn't believe that she was violent.
Oh, you guys speak up.
Detective Lieutenant Toth stated that he believed that he did not believe
Your,
that.
I would just object to
She's
the
fine.
hearsay of this testimony and saying what Detective Lieutenant Toth may or may not have said.
It goes to character.
It's hearsay.
It's,
What's the
It's a-
objection?
it's
It's a hearsay
allowed-
objection. It's a
allowed-
hearsay objection.
And I'm giving you the hearsay rule. It's MCR. I mean, MRE. Just 1 second. It's MRE 83121. I'm gonna find it in a second, trying to move fast. And it goes to her reputation in the community.
But, Your Honor, my objection is that she
I
is
know.
asking Detective
I know.
Salomon to testify as to what Detective Lieutenant Toth said.
Right.
It doesn't get to the,
It's a hearsay objection, so you can respond with hearsay exemptions.
Which is what I
It's
just
obvious,
quoted
it's
you.
obviously not a out of court statement you're trying to introduce. So that makes it hearsay. Does it meet one of the hearsay exemptions?
Presence, were you present during these conversations between her, Officer Toth, and you?
Yes.
Okay. So presence and impression, number one. Number two, it goes to her reputation in the community.
Which
Which
is
is
not an
a-
exemption to hearsay.
MRE 803.21.
But counsel, you have to get around the hearsay exemption first. If you want Toth on the stand to talk about what he said about her character, that gets under 801 or 831. It's not a present sense impression. Sustain the objection, move on.
thank you, Your Honor.
It also would come in at 8:03.
Council, I
then
ruled,
existing-
I ruled, you may appeal me gladly. I love it when the circuit court gets involved in my life. Move on.
You did just testify to what was in the police report, correct, sir?
Yes,
Okay,
it's in the police.
I'll move on. And I think, Detective, that is it, but let me confer with my client. Nothing further, thank you, sir.
Ms. Manarino,
Your Honor, I have no further questions for Detective Salaman.
all right, do we think we've got anybody we can handle in an hour?
Your Honor, the people rest, I have no further questions.
I knew that,
Yeah.
because you said you only had two.
Yes.
With the idea that the jury wanted to break in about an hour. It's 11:33 now.
Can I confer with, I
Sure,
think I
sure.
have one witness outside.
Take a minute.
Want to see if she's still out.
Take a minute, sure.
Your Honor, can we send Detective
Oh,
Salaman?
yeah,
on
I'm
his
sorry,
way
I'm
to
sorry.
go?
Get back to
do
work or
Sumter
life
Township
or
things?
whatever you're supposed to be doing.
It's so nice to see you grown into your ears. You're such a good.
I can't believe you've been a detective for 10 years. He makes me feel really old. I feel really old. He used to be this little kid standing at the 4-H auction with these great big steers, and his ears were out to here. Ma'am, come on up. How are you?
All right, you.
Good, nice to see you, nice to see you. Would you raise your right hand for me, please? You're going over here. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
I do.
Settle in that chair. State your full name, spell your last name.
Okay. Peggy Ann Miller Morgan, Morgan.
Thank you. Go ahead, counsel.
Thank you, Your Honor. Good morning, Ms. Morgan.
Good morning.
What is your occupation?
I am a Sumter Township trustee.
And how long have you held that position?
I was elected in 2004 and I've been in office since 20 years.
20 years, okay. And do you know a person by the name of Timothy Bowman?
Yes, I do.
And how do you know him?
I met him when he was running for supervisor for Sumter Township.
Okay, and how long have you known him?
Let's see, he ran in 2000, about 3 years now.
3 years, okay.
Yeah.
And do you know a person by the name of Sheena Barnes?
Yes, I do.
And how long have you known her?
I have known her probably since about 2003,
Okay, all right,
so 20 years almost.
20 years, okay. And you are aware that Ms. Barnes ran to become the treasurer of Sumter Township in 2022, correct?
Yes,
Okay. And given the length of time that you've known her, what was her reputation in the community? Her character and reputation?
oh, she
your
had a
opinion?
fantastic personality. People loved her. People came from all over the place to have her food. She's in the business and she has her own business at her house. And she's just very caring, thoughtful, religious,
Okay.
loving person. I couldn't ask for better.
All righty, thank you. And now, you are a person who writes articles and gets them posted in the Independent with respect to political campaigns, is that correct?
Objection relevance.
It's relevant as to what took place in 2022 and relevant as to Mr. Bowman's reputation in the community.
Your Honor, his reputation is not an issue in this case.
And it's not relevant.
May I ask her about his reputation in the community?
No, it's not relevant.
I think it's relevant, Your Honor, as,
Counsel, I understand your theory of the case. By now you understand what I think of it. It's not relevant.
very well.
Appeal
Nothing
me.
further, Ms. Morgan. Thank you.
Any questions for Ms. Morgan?
No, Your Honor, none. Thank you.
You can step down now. Watch your step.
I would like to call Ms. Barnes now, but I think that her testimony may take an hour. I don't know if you want me to start now and then finish after the jurors come back
Well,
from lunch.
if it takes an hour,
We're okay?
we're probably okay.
Okay. At this
Once
time,
again,
Your Honor, I
if
would
you
call
get
Ms.
tired of waiting, just let me know.
At this time, I will call Ms. Sheena Barnes to
Okay.
the stand.
Ms. Barnes, you've heard me warn everybody about the ramp, so be careful. Raise your right hand for me, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you, ma'am. Settle in the chair.
Just looking for my notes, Your Honor.
Yep.
Okay, Ms. Barnes, how long have you lived in Sumter Township?
I've been in Sumter Township for 63 years.
Okay. And have you ever been convicted of a crime?
No,
And how old are you?
I am 63 years old.
Okay. And did you, you posted prayers on your Facebook page on a daily basis?
Yes, I posted for the last 6 years,
Okay.
excuse me, 4 years, every day.
Okay. And do you know a person by the name of Mr. Timothy Bowman?
Yes, I do know Mr. Bowman.
And how do you know him?
How do I know him?
Mhm.
Him and I used to rent from the same landlord back in 2003 when he had his tree business and I had my barbecue business. So we go back.
Okay. And would you describe yourself as a political activist before you ran for the office of treasurer in 2022?
Somewhat, yes.
Okay. Have you ever held any type of office in Sumter Township?
Have I ever had hold the office? Yes, I was appointed as Sumter Township trustee
Okay,
In
for how
2000.
long did you hold that? office?
for a year and a half, close to
Okay.
2 years.
All right. Now, you would agree there was a lot of campaign bantering between you and others, including Mr. Bowman, regarding your agenda?
Yes,
Okay. And did Mr. Bowman attend a rally that you held?
Objection, relevance, Your Honor.
It's as to why he did what he did.
What did he do? He's accused of nothing.
He went to the police. So
That's
he
not
must have
accurate.
thought something took place, and I'm trying to let the jury know why he did what he did.
Why he reported
When was
that
the,
he
when was the rally?
What month was the rally?
the rally was before August the 19th. Before I made the statement, the rally was before the primary.
It's not relevant.
Thank you, Your Honor.
With respect to the message that we've heard him
Mhm.
and the prosecutor talk about, did you send that to him as a private message through Facebook or as a public message?
It was personal, private, just only for his ears only.
Okay. And could you explain to the jury what you meant by, first of all, was it meant to be a threat that you were gonna stick a stick up him and it would come out his wife?
I was merely being facetious. Clearly, I can't stick a stick up somebody's rear and come out of somebody else. I was really being facetious.
And was
And-
that done in response to all the bantering that was going on
Yes,
between the
it
two
was-
of you? It is relevant, Your Honor, as to why she sent the message.
I think it's relevant as to why she did what she did.
Okay, thank you, Your Honor.
Because of all the bantering, that's why you sent that message, is that correct?
Yes,
Did you send it directly to him?
I sent it
Mr.
to directly, privately, only to Mr. Bowman.
Your Honor, I'm gonna object. I don't know that whether or not it was private or publicly posted has anything to do with the offense that she's charged with. If it was, the fact that it was made private or publicly doesn't change the fact that it was.
I'm gonna object to the council
Let her
arguing
finish,
throughout
counsel.
this trial. She's
Let her-
basically doing arguments.
She's
during the
making
trial.
objections, and let her finish before you respond.
Objection as to relevance as to that.
You're objecting as to relevance to her objection?
I'm objecting to her saying that how the Facebook message was sent is not relevant. I believe that's her objection. I think it's
That is-
relevant that it was sent privately rather than publicly posted so
Why?
everybody could see it.
Why? Elements of the crime. Why is it private or public matter?
Because it was just between the two of them and they know what was going on between the two of
Elements of
them.
the crime, does the crime charge require it to be private or public?
That's up to the jury to decide with respect to
No,
whether or
it's
not they
not.
thought
Ms. Young,
that the
Ms. Young,
message
please,
was a threat.
please. The elements of the crime, you've read them. Is there a component in there that makes private or public relevant?
If I'm out in front of somebody's house with a gun, holding it up, saying, come out, I'm gonna kill you, that's public. If I sent somebody a text message because we're bantering between each other and I do it privately, it's a question of whether I mean it or not.
You've changed the scenarios.
I have not changed it.
Yes.
I use an example to answer your
Well,
question.
let me give one. If you stand outside my house and publicly yell, you're going to kill me, or you call me on the phone and privately yell, you're going to kill me,
There was
are
no
equally
yelling.
in threat. Move on.
It depends
Counsel,
on
I'm
the
going to hold
content.
you in contempt if you continue to argue after I make
I
my ruling.
apologize, Your Honor, but
Don't apologize. Stop. Move on.
Thank you, Your Honor.
so I cannot ask her that question. I'll move on. What was your intent again, Ms. Barnes, when you sent that message?
My intent was again, I was really, didn't mean any harm. I was being jokeful. I mean, truthfully, how can I? If I was really serious, then I don't even really remember where he lives. I would go to his house and stand outside and say, I'm here to stick a stick up your ass and it's gonna come out your wife and I'm not gonna leave until I do it. If I truly wanted to do some type of physical harm to a person, I wouldn't call him on the telephone, being facetious, saying, I'm gonna stick a stick up your ass, you're gonna find it coming out your wife. How many times have I said that before in my life? I'm sure I've said it more than once in my life. I'm sure I've heard it before, other people saying they're gonna stick a stick up somebody's ass. I don't find that that's gonna do any type of bodily harm physically, that I can physically stick a stick up somebody's ass and it's gonna come out of somebody unless they're gonna lay down, let me stick a stick up his ass and then wait to come out of his wife. I don't know how I could possibly, truthfully, beyond a shadow of reasonable doubt, could do that.
Okay, and then were you sending the message in order to harass him?
Absolutely not. He was going back and forth with me over and over. He made the first public, maybe 3 or 4 times in public, he offended me and I didn't bother. I just said, this is political, I'm gonna just let it slide. I was being intimidated. I was being pin stuck in by Mr. Bowman. He was, as he had been yesterday. He called me yesterday. He called me the day before. He's a bully in my book.
Nothing further.
Your
I have no
witness.
questions for this witness, Your Honor.
You can sit down, ma'am. Any other witnesses from the defense?
No additional witnesses for the defense.
Rebuttal witnesses?
None, Your Honor.
Okay. Close.
Ladies and gentlemen, thank you for your attention during this trial. In just a moment, the judge is going to give you the final instructions before you go into the jury room to deliberate. As you deliberate, what you are going to be asked to decide is to decide whether the message that we played for you this morning from August 19th from Ms. Barnes to Mr. Bowman was a threatening message. It's clear that Mr. Bowman, from his testimony, found it threatening to him and to his wife. As you are thinking about whether or not you feel that that message was enough to be threatening, I want you to take into account all the testimony that you've heard and seen this morning. And when you're evaluating that testimony, think about the demeanor of the witnesses as they testified, what they said, what you heard, and take all that into account. And I think that once you focus on all of the evidence that you've heard this morning, you will be convinced that the message on August 19th that Ms. Barnes sent to Mr. Bowman was in fact intended to be a threat, and that that is exactly how Mr. Bowman and his wife perceived it. Based upon that, I would ask that you find Ms. Barnes guilty. Thank you.
Ms. Jones.
Thank you, Anna. Well, this went really fast, ladies and gentlemen. In order for you to find someone guilty of a crime, the judge is going to give you a law, you have to, after having heard all the evidence, decide whether you have some reasonable doubt, about whether, oh, I'm sorry, so sorry. Whether you have some doubt, reasonable doubt about whether or not you think it was Ms. Barnes' intent to threaten or do physical harm to Mr. Bowman when she sent that coarse joke. It was not her intent. She told you what it was, that they've been going back and forth. Mr. Bowman even admitted he was laughing about it. Said she's crazy. She's fucking crazy. He said the only issue he had was what he found objectionable was the stick coming out of him and then it coming and going into his wife, which you know that's impossible to do. That's obviously a joke. There was no evidence whatsoever with respect to his wife that Ms. Barnes sent any text messages to her, any voicemail messages to her. None. It was just to him. So if she learned about it, he caused that to happen, not Ms. Barnes. So don't hold that what his wife felt or what his wife thought. He caused that. It wasn't sent publicly, and that's why I made that a big issue. On a Facebook post, it was sent privately just to him. It was not her intent to inflict any harm or injury on Mr. Bowman. And after having heard all the evidence, you clearly, ladies and gentlemen, have to have some doubt as to whether she intended to cause him physical harm, or she intended to threaten to do physical harm to him. Truly a true threat. It was not. It was coarse joking. So I'd ask you, based on the evidence that you've heard, and based on the doubt that you've got to have in your mind, based on what Mr. Bowman said, to find her not guilty of this crime. And thank you so very much for the close attention. I do believe that you each did listen very carefully to the evidence. I was watching you as we were going through, and you did each pay close attention. And I appreciate that. And Ms. Barnes, and I thank you very much.
Rebuttal.
Thank you, Your Honor. Ladies and gentlemen, as you deliberate, I want you to think closely about Ms. Barnes' testimony. During her testimony, she said that if she really wanted to threaten Mr. Bowman, she would go to his house and she would use the same words that she used on that message. The difference in her mind is the proximity. So think about that as you're thinking about what her intent was with that message. It's clear from her testimony that she was upset, she was heated, and she made that call because she was upset and her intent was to threaten him, because she would use that same language standing on his porch to threaten him. Thank you.
Thank you, Lee. All right, so folks, the next step is for the two attorneys and I to have some conversation, hash out the final jury instructions. Heather has to make some last minute updates so that what you've got in your laptops or your iPads match what we've agreed to. That process usually takes about 20 minutes or half hour. So my suggestion is that have you guys go to lunch, try to keep it at a half hour. Hopefully, by the time you get back, we will have all done our work, and then I can give you final instructions, send you in to deliberate, and go from there. Does that sound reasonable? Okay, so I'll remind you, don't discuss with amongst yourselves or family or friends or anything else about what's happened today. After the close of the trial, you can talk about it to anybody you want to. But in the meantime, just forget about this trial until you get back. All right, thank you.
We had a pen. I had a pen.
Enjoy lunch. Please, I'm going to ask you to do this, and the rest of you can take a break too. I'm sorry. Take a look at the final instructions as they show up in your iPad. Make notes if there's anything you don't think there was any testimony that supports giving it, or you think we need something new, and just you can do that. I mean, you don't have to do it right now, Angela. I mean, you can take a second, go to the bathroom. You know,
I was just trying to figure out how to get in here, sorry.
come on up. You got it, Angela? Yeah.
Yeah, I know it.
The hardest part is being able to see that little tiny sub.
Yeah, it's just like my time.
Yeah, yeah.
So.
All right. All right.
that's-
So
you
take
should
your
look at
time.
it from there.
And when you two are ready, that you two have both reviewed and made your notes, let one of the guys know, and then I'll come out and we'll hash it out.
And Judge,
Okay.
the only section that we're looking at is just the final instructions, or do we need to?
Correct.
Okay.
I think
so
that's the only,
yeah,
I think that's the only thing that
everything's in
changes.
there, I
Yep,
guess? Okay.
yep. I mean, the evidence instructions, you can go through it all. I don't think go through it all. Go through those
Okay,
last
so
three,
those last three.
the last three sections of the submenu.
Okay.
For example, I know in witnesses section, it talks about the number of witnesses.
So
Oh,
it's
okay.
just the final, the evidence, and the witness.
Okay.
Yep,
So those
yep.
are three.
Thank you, Ms.
Thank you.
Manuel.
Yep.
How to take a break.
get a chance to go through everything.
Mhm.
So I don't know, I mean, I think there's probably some that don't apply, but I don't know,
I
in
can
like
give you
the
my,
evidence and witness side.
yeah, I can give you my list.
Okay,
There was no stipulations.
Right.
We need that.
yep,
There was no flight, concealment, or escape,
yes,
so we don't need that.
right,
There were no expert witnesses.
yes,
And we don't need the instruction regarding the witness speaking to a lawyer, I don't think.
correct,
And, did I say stipulation?
yes.
Yeah, okay, and
Yep.
then, since you object to, basically what I would describe as motive, then I don't think we need to give that instruction.
I mean, yeah, that's. I mean, if you don't want it, I guess it's fine.
Okay, so those are the only ones that I saw that
Okay.
we really don't need.
And then I think that we, is that, and then the witness ones, we don't need.
Yeah. I told Ron, doing it with a burger just wasn't. Yeah.
Okay,
All right, ladies, and you don't have to, this doesn't have to be on record. Final instructions. Anything I'm on page 1, final instructions. Duties of judge and jury, presumption of innocence, burden of proof, reasonable doubt. I'm going fast. Stop me if anything you want to talk about. Evidence. Witness credibility. Anything in any of that so far that we need to talk about?
The only thing that, I saw is just the time and place. It says August 18th, and I think
Like-
it was August 19th.
I gotta find it.
It's on page 5, the top of page 5.
Oh, okay, yeah.
That's my only, yeah,
Yeah,
that was my
yeah,
only thing
yeah.
I think on that.
And elements of the crime, elements of the crime, we've already hashed that out.
Yes, yeah,
Right,
yeah,
okay.
we agreed on that one.
Are you okay up to time and place, Ms. Young?
yes, sir.
Okay. Deliberations and verdict, pretty standard, I think. Penalty, communications with the court, exhibits, we had exhibits.
The only, so, we say, oh, I guess if they want to take, yeah, so if they ask to listen to the recording again, I guess we can play it, but that's, because they can't take that one, I don't know if they're gonna take the other, the paper, exhibit.
Right, and when I talk about the fact that they can take the paper in with them, I'll let them know if you want to hear the audio evidence, then you'll have to let us know. You know, we can bring you back into the courtroom. for
Yeah,
that.
that's fine.
Instructions in the jury room, verdict form. You haven't done that yet, have you?
We have, it's just, man,
Thank you, Ms. Manarino.
yeah, this one's fine to me, yeah.
Yep, that's fine. Thank you.
Thank you,
Thanks,
ladies.
Heather.
All right, now we're getting into the other sub heading of evidence instructions. Page 1, defendant statement as evidence.
There was no statement, John.
Well, so the call is, I mean,
Yeah,
the call is the statement that she made, I mean, there wasn't really any, and the only other thing.
yeah, but this is about statements to the police.
Right, because the only other statement was Salagen testified that she said that she made the call, but I don't know that she's disputing that. So I don't, I mean, I guess. I don't know if that's one that maybe is, you know, super important.
I don't feel strongly either way. Do either one of you?
I don't think it needs to be given your.
We'll leave it out then.
Okay, that's fine. with
You
me.
got that, Heather?
No, I'm going into it right now. to
Okay.
see if
I'll make a note.
You're making it up.
Yeah. Okay, moving on, circumstantial evidence. I don't see that we had any circumstantial evidence, do we?
No, I don't think so.
No.
So scratch.
Okay.
We can strike it.
Certainly, there was nothing about flight concealment. No prior inconsistent statements,
Right.
No,
scratch. I don't think we had any steps.
we did not.
Agreed.
Um,
We could strike the motive one.
I don't know. I'm not strong about it, but because intent is such a big part of this, motive and intent.
Prosecutor has no.
No,
objection to it not
I think leave motive out because the intent instruction is there. So we'll scratch motive, leave intent.
And then, so yeah.
So there's not too much in that section that stays. Are you there yet, Heather?
Are we on,
Evidence instructions.
okay, so what are we getting rid of?
Basically, we're getting rid of everything except intent.
I think so.
Agreed? In that
yes.
section?
Yes, that's correct.
Then moving to witness instructions?
Mhm. We can get rid of the impeachment by the prior conviction.
Yeah.
Great. There was no expert witness too, I don't know.
No.
Yeah, and the
I
witness-
think we scratch one, leave two, just starting at top of page one.
Mhm.
Scratch one, leave two. Number of witnesses, I think makes sense. We haven't really had any conversation about witness
No, so that can go out.
prep. Uh, Character evidence, there was there was enough discussion about that it should probably stay. Any objections?
Yeah, I think that one would probably leave it.
No objection.
All right. Going to page two, scratch expert witness.
Yes. The police one, I mean, we did hear from the
Yep.
police. I don't know if there's much
Yep.
with
Yep.
that, but I think that's it.
Yep. Okay, so we'll let Heather catch up.
We
I'm
did
just
like
gonna write
No,
down
that's all right.
expert
That's all right.
witness. So get rid of number one, what about number two?
You, at top of page one, scratch one, leave two. You should judge this witness's testimony. No. Scratch the
No,
whole thing.
I was down
Oh,
at
yeah, the
page two,
entire,
so-
yeah, the entire impeachment one comes out.
Yeah. No, go back up to page one where witness impeachment by prior conviction.
Okay, so get rid of one and two of there,
Yeah.
okay.
And then weighing conflicting evidence, leave that. Scratch the witness and the lawyer.
And it's been interviewed by
Yep.
the lawyer,
Yep.
okay.
Leave character evidence one and two. Now we're on page two.
Yeah.
Scratch expert witness one and two. Leave police witness. All right. Now, what do you do? Send it to them? How's that change
All
that?
they're gonna do is just push their button and it refreshes.
Magic.
Okay.
But, wait a minute, did we change anything on final instruction?
I gotta
I
get
didn't
back.
realize I could do this out here, I thought I had to go to my office,
Oh,
so I'm very.
I don't,
No,
Final witness is good, I already updated the date.
yeah, I think the, yeah, okay,
Yep.
oh, yeah, it's already on mine.
Yep.
Yes.
Yep.
And then, yeah, I think that was.
bless you.
Yeah,
Bless
that
you.
was, I think, the only thing.
Okay, so then evidence instructions, all of that stays?
No,
All of it goes except intent.
yeah, except the very
The last one stays.
So only intent, so all.
Yes.
all
Yep.
of that.
Everything else in the evidence
Now, which
section.
one? I'm confused
Defendant
about which one
statement
that
and
is.
evidence.
We're talking about all of this?
On page one.
No, no,
defendant
no.
Statement and
Oh,
evidence,
these
and
ones.
all that goes.
I gotta get
Oh,
there.
okay.
I gotta get there.
Sorry.
On page one.
No, final instructions, yeah, we're on the evidence instructions.
Oh, okay.
So yeah, everything except intent, that's the, the statement.
So
Yes,
that is-
yes.
Yes, I agree.
Yeah, yeah,
Page
okay.
two is, I know everything goes stipulation and motive, and we keep intent, correct?
Right.
Okay.
Yep,
What
But
about on page one?
of the evidence instructions?
Yeah.
Yes, everything goes?
Yeah, those are all out.
the whole section, don't worry about pages. The evidence instructions, that whole section, everything's gone but intent.
Update,
Yep, it's updated.
we're good.
Where did you
Yeah.
change the date? I want to make sure I got it.
Oh, yeah, I saw it.
Final instructions, it's like way down towards the bottom, it's on page five.
And then they'll need to just refresh.
Well, actually, we'll
There's-
refresh them all before they get back in.
Okay,
Yep, so we're good?
Yeah,
yeah,
yeah.
to the top of page 5.
Heather can refresh them and then check to make sure they all got
Okay,
refreshed, if you would.
Yep, yep.
Okay.
Close
And
this
then,
out.
so we're good, we're just waiting for them to
Just,
come back.
just gotta have them come back for lunch.
Perfect. When it's almost 12:30.
And all I have to do is go back to where it says the sub menu.
Yep. It's so nice.
It's very different, because I mean, I remember when we used to do the jury books with Paula, and it was always like
Yeah. And now all I have,
horrific.
This is nice. It's the first time I've seen it like
It
this.
takes a little getting used to, council. Trust me, I did pay for it.
Oh, what time do you have down for the sixth with, when I bring my newbies in?
Noon.
Okay, perfect. That's what I thought. I just want to make sure I told you that. Because Schultz texted me the other day and he was like, are we good? And I was like, yeah. So I have to double check with Heather to make sure. I'm looking forward to that because these are like new newbies that I don't really, like, I don't. Oh, so it'll be. I'll see everyone at their greenest.
Heather, when you're done with them, put them back to all stuff.
Oh, okay. I already did all those, so
Going out to
send
final
these to
instruction.
Hey, we're ready whenever, you get all your. Thanks. Where's my? You know my little thing that's got the little numbered beads in it?
your what? Sorry.
I got a little tin box that's got numbered little wooden balls, 1 through 7.
There's all the jurors are back. The court officer let me know there's just one that's using the restroom,
Okay,
but everyone's out in the hallway,
Okay.
so I think when that last one is back,
all right.
they'll,
Ms. Young, excuse me, are you ready to start? The juror's all back.
Yes, Your Honor.
Jury is all back.
Yes,
We'll
Your Honor.
talk today. So I always ask this question. I hate it when we get 7 people and they've all, done the job and then I kick one of them off at the last minute. So I've had a few situations where nobody objected to going with a jury of 7. But I'm going to ask you, hold on just a minute, Ken. Just 1 minute, folks. 1 minute, 1 minute. I'm sorry. 6 versus
I
7.
see that right here.
No objection, Your Honor, keep it all 7.
Okay, great.
Yeah.
Okay. Yes. I'm absolutely amazed that you folks were all able to go out, get something to eat, and get back in a half hour. So I'm assuming some of you probably didn't bother eating, but I won't ask. My picture is outside. I'm not sure what one you looked at. Yes, that was 20 plus years ago. Yeah. And no, I'm not updating it. Thank you, folks. Have a seat. All right, we're back on the record for final instructions. I just had I forgot to do it before, so that's why I just kicked you out as you were walking in, because I wanted to have a conversation with the attorneys. We're not going to have a jury of 6 deliberate. We're going to have a jury of 7 deliberate. And that's always bothered me as a judge, that, you pick 7 people and 7 people pay attention, 7 people stay awake, and they're all giving it their best. And then at the end, and sometimes at the end of a long day, I say, okay, randomly, you're out. And that always rubbed me the wrong way. So I always ask the attorneys. Sometimes the attorneys object, and then we pull somebody off and the alternate goes. So you folks get to work as a group of 7. So here's the final instructions. Once again, I apologize for showing you my forehead. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my job, it is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to reach your decision. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Ms. Barnes is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find Ms. Barnes not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that I'm not reading the multiple charges because it doesn't apply here, agreed?
Agreed, Your Honor.
Agreed,
you.
John.
The lawyer's statement and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The defendant is charged with the crime of malicious use of a telecommunications device or service. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant used a service provided by a communications carrier to communicate with the complainant, Timothy Bowman. Second, that when communicating with the complainant, the defendant threatened physical harm or damage to any person or property of another in the course of a telephone conversation. And third, that the defendant did so with the intent to terrorize, frighten, intimidate, threaten, harass, annoy, or disturb the peace and quiet of the complainant. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts or circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard evidence about the defendant's character or peacefulness, honesty, and being law-abiding. You may consider this evidence together with all the other evidence in the case in deciding whether the defendant committed the crime with which she is charged. Evidence of good character alone may sometimes create a reasonable doubt in your minds and lead you to find the defendant not guilty. The prosecutors cross-examine the defendant's character witnesses as, actually, you didn't cross-examine Ms. Morgan.
I did not.
I don't think that's relevant instruction. Do you, Ms. Young?
No, you're,
Paragraph 2.
that's fine. You can.
Thank you. Moving on. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Ms. Manarino, Ms. Young, are you satisfied with the instructions as given?
Your Honor, if I may.
Sure.
After the court read the elements of the crimes charged, which is on page 4.
Yep.
There's page 5, which begins with time and place, and I believe.
Oh, I think I
Ms. Young
skipped
and
that,
did
didn't I?
not hear the court note for those.
I got to find it again. Thank you.
So if you read
Yep,
those, then.
thank you, thank you.
Thank you, Your Honor.
The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 19, 2022 within Sumter Township. When you go to the jury room, you will be provided with a written copy of the final jury instructions, electronic. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instruction. If you want to look at any of the evidence excuse me, if you want to look at any of the reference documents or exhibits that you've been admitted, you just ask for them. There was one exhibit that's not written. We can't hand that to you. That was the audio recording. If you do want to hear that audio recording again, we'll bring you back into the jury room. We can play it out here. I don't think we have the ability to play it in the jury room. So we'll bring you back out here and play it here. When you go to the jury room, I'll have given you electronic copy of the instructions you've heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. And I have had Heather prepare a verdict form, which is here, and Officer Garcia will take it into the jury deliberation room with you. Now, ladies, are we satisfied with the instructions as given?
Satisfied, Your Honor.
Satisfied, John.
Thank you both. Jamie, if you'll take them in. And once again, anything you leave here, if you want to leave jackets or anything like that, it's perfectly safe. The courtroom's not going to be empty. And if it is empty, there'll be one of our security guys outside the door and nobody else. Thank you. Yeah, folks, and there should be water in that fridge if there's not. Okay, thank you. Yes, you don't have to. If you're not going to use it, leave it where it's at. It's fine. Use it if it's helpful. And we are in recess.
Thank you, Your Honor. Do you want to pick a date for another person while we have some staff? Yeah. Okay, Friday. I couldn't remember where it was. I didn't want to go. Okay, thanks, Heather.
Yeah, that's true, so it helps you.
I mean, I wanted to, when we did the.
Yeah. Right, but this is the first real.
Yeah, anyways, what is it?
June.
You guys are.
Well, 'cause Marion off.
Where's she going? There is no one. Actually, oh, the unit attorney that I had, that I did that, he has, somebody else was responding.
Anything else? Yeah,
There's
it's
some
just
kind of environmental. Anyway,
And
okay,
so
so
there-
you're at Arnsberg, you do, are you guys splitting up?
We have a partner in that. We're covering a lot of her stuff.
Okay.
So, are you?
So, does the court close for Juneteenth? So I have June 26th, because I have a free trial. Oh, yeah.
And they're like so busy. Like some weeks, I know, so they're giving us two.
Well, because they're so big that you're taking, instead
Yeah, yeah.
So Mondays are hard in June, only because I have my nail doctor on the 12th and I have a river rouge day stuff there. So,
And the fifth is coming Tuesday.
yeah, what
Oh,
about,
yeah.
I could do, what about the 13th? I could do like, and it's right, or like, Tuesday.
Can you do it then?
Yeah.
Okay, because I looked at it, because I have exams up until 11.
Yeah, we could do it, yeah, we could do like 12:30.
No. If
Oh,
it
you
was
want to do one?
Yeah, no,
So one?
so one.
Yeah, that works for me. That's perfect, then I can do, I'll do Zoom with Jeff Green, just ready for it. And then,
But are we gonna have it up then? Are we, do we have them all in already?
well, my lease is next week, so I don't.
It's not, that's not, I don't see it, but is that not time?
They should be all here.
Yeah, that's 3 weeks.
How do you run this house? Yeah.
No.
Oh,
And he's doing, or whatever. Yeah, he's promoted, yeah, and he has.
the Romulus officers I know. I know the Perkins.
Oh, wow.
And I would know the rules for Friday and,
What was the first one?
I was talking to he's in love and not busy. He's him.
Please don't. This isn't Philip brought the dead dog to the wedding.
No,
Oh.
no, but Annie, no.
Is she maybe a little bit more safe?
Oh, yeah, she's like, gosh, the pressure's on, I mean, it's. It's like, I read.
That is very
It's
good.
a very busy day.
That's
I'm
very
like,
good.
age appropriate girlfriend.
Yeah, so then that means if he decides to retire, he has something to do. That's why he can retire. Or at least he's probably outside.
Yeah, I know. But I mean, they're like Asian law and it's.
But, and, or if you don't have other hobbies,
Yeah,
that is your hobby, you have nothing else.
well, yeah, and I think like all the stuff. That happens to be, but. So, I mean, the kids are, and so I think the kids are okay, like.
Yeah, something to do.
I know,
Maybe.
right,
Yeah.
yeah, I think she's the first. Yeah, oh yeah, they've known each other for a long time, and she apparently always knew she was ready. But then something happened and, yeah. I know. I did come a couple weeks ago because, also the last stuff was, 25 long. It's one of the few new birthday in your house is ready, just remember, like, yeah. So she called me, I like 9 officers, and I just forgot, she was like the last one, I forgot. I was like, how did you find out? She's like, Freddie called. I called. I was like, she is the only one who you're afraid of. Whoa. Also,
Yeah, that's like my dad, who doesn't really do anything but work and yeah. And like, so he was trying to sell his business, he, does fix demo equipment. So it's like not a big business out there. Yeah. And, he's trying to sell. And like, tired, so.
Because my dad retired in 20. My mom retired in 20. And yeah, they're definitely retired from that. My mom retired in
That's good.
2019. And like, because my mom said that she would work longer because my brother. So she told my dad at the office, that everyone. And she's like, well, you know what I mean? Like, I wasn't like, oh, wait for it. But yeah, so they like, you know, had like, they like, but they haven't. But they just doing stuff, hanging with their friends, like, they work out every day, like, they're so busy. My dad's like, but it has time to work. Because my dad was about, my dad was for retired. They have like 9 months after he retired. And the way they did it, like, you have to retire earlier. Because they were like, oh, you'll work for like 6 months or whatever, and you'll work like every other week, you can like upgrade your replacement. Well, we worked with the first 3 months of that 6 months, we supposed to be working every other week. I mean, I've already put in all the time. So we have like a good time. What was any other time? Yeah, it worked out well for that. But there's some of the time goes by. And I was like, well, you just keep doing things. Yeah, and then when they hold schools like in the summer, they like people play like what happened.
That's so fun.
Yeah, and then that's what you do.
It's like, well, my dad has his second family. He has some stroke.
Oh, is he like younger?
Well, his kids are my kid's age. I mean.
Oh, okay, yeah, so he has like, yeah. I mean, they're not like younger now.
No,
they're like,
they're 30s,
yeah.
but they've never had to take care of themselves. My dad has always. And, so
Are
he
you
has.
supposed to get a last?
Well, he thought he was, and then.
Really, that worked out well.
Yeah.
Yeah.
Because like his kids are just so spoiled.
Yeah.
And like the one has an apartment that he's having paid for, because she doesn't always work. And then the other one, she bought a house and we had to help her buy that house, because she only works at a nursery. And her boyfriend that lives there, he never wants to work. And their cars, he's always wanted to pay for. I mean, it's just, it's like nothing that he's ever. Because I asked him, because they keep telling me that the one, they're getting married, and there's one daughter.
Okay.
Is getting married, and the guy, his name is Dan's parents are saying, no, we don't want that, they need to change it. So they changed it. So then they want to change the menu. And I'm like, yeah, so tell me, if they want to do it, they can do it. Well, I asked, were they paying? And he goes, oh yeah, they're paying for a lot of it. Oh, and I'm like, oh, I go, and then he's saying how the end is gonna cost the job. And I'm like, so do they pay for a lot of this stuff?
Yeah.
For somebody that
Oh,
age
so they're
to
both like,
yeah, to decide.
capable of like taking care of.
Yeah. I mean, Nicole, my sister could,
Yeah.
but not in the capacity that she has. So obviously
Right,
she's
right,
doing
she
now.
can work. But
Yeah,
like,
yeah,
not-
she works, she always
Yeah.
has.
But it won't be the lifestyle she can.
Exactly. And so I'm like,
Work that he does with the parents.
yeah, and I go, does he, you know, get money from his parents?
Yeah.
For him to be that age to say, you know, I don't want to work right now. You know, just let him. And he's like, well, kind of, but then he started thinking about it. Not working. But at least when he.
See, when I was 17.
Oh, yeah, because that's right now. Okay. Yep. Harder for her to hide from me. Unless they lock me up. Yeah. So I can just grab this down.
How would you take that? I would say that means they're asking us to fight.
Indeed, yeah. Yeah, that's.
Yes, Steve.
Yeah, we had the evidence up on top.
We got it, yeah, yeah.
All right. Thank you. Thank you.
So we're supposed to have dinner tonight with the Malloys. Dawn and Vanessa are both sick. Both feel like they're swallowing razor blades. So we just said, you know, we'll just do it. Whoever shows up, shows up. It's so hard. I do, but it's so hard to get people's schedule anyhow.
Yeah.
Because, you know, Susie didn't want to do it on Monday because she's got both kids and the dog all day. She's trying to figure out what she's got in the freezer, which I said, just order pizza. They're not coming over for food. Just order pizza. I said, why just schedule it on Monday? She says, that's all. That's the only time I could get them all together. You know, between Steven's goofy, you know, 4 days on.
True, yeah.
And then, you know, a bunch of other busy adults. She's doing some subbing, like rarely.
So that's why Susie has the kids and or does
She-
Susie get them in
She has the kids every Monday.
trying on
She's
schedule?
got it scheduled, so, you know, that might be a day where she just tries to write all day, or that might be a day where she's scheduled
Getting
some
her shopping
appointments.
done, yeah, appointments. So it's just Monday.
Well, that's the standing. It's every Monday, and then, you know. Have a seat, ladies. So what my mom's last name. Furniture right in front of it. Feel, and it starts to crawl under. Got his head under folding chairs, right? He's got one head under there. Inside the space between the front. Luckily, my nephew did one of these. I said, you're getting good stuff. Have a seat, folks. Thank you. Yeah, Heather's got that. All right, back on the record. And Ms. Johnson Bowles, it looks like you might be holding the verdict form.
Yes.
I'm gonna guess that you are the foreperson then?
Yes.
All right, would you share with us what the verdict is? Oh, you can if you feel good. Yeah, I was just gonna say, that's what they do on TV.
We, the jury, find the defendant Sheena Davina Barnes not guilty of malicious use of telephone.
Good, you got it.
Okay.
All right. Your decision, sir? Mr. Corvo? Yep. All right, and Ms. Bridges, your decision? Mr. Jackson, your decision? Ms. Flora, is that your decision? All right, and Ms. Marion? I got it right? Is that your decision? And Ms. Schultz? All right. You folks are not released yet. We're gonna put you back in the deliberation room. I'll be there in just a minute. Ladies, thank you very much. You do not have a cash bond posted. You're free to go.
God bless you.
He has.
God bless you.
All right, take him back if you would. Folks, just leave your steno pads, iPads, just leave it all right there. You may. With the Zoom and everything? Yeah. Yeah. I'll click all this stuff off up here.